Securing evidence in criminal cases requires meticulous, legally compliant procedures to ensure the integrity of the evidence. This is the view of at least one legal expert who believes contaminated evidence can tank a case. Legal expert Advocate Jazz Vilakazi joins us now to speak about processes of securing evidence for successful prosecution. Advocate Vilakazi, good evening. Thank you so much for joining us. Really do appreciate it. The law of evidence is a very contested terrain of our jurisprudence, but one that is largely settled on its foundational and almost non-inalienable principles around the integrity of evidence. But when we speak about tampering with evidence, what exactly are we speaking about?
Thank you for having me on your show. Evidence is one of those elements which are almost conclusive in nature. Think of a video recording, it records silently and many persons have been convicted on it. So one of the basic requirements of the Constitution is the ability to challenge and to adduce evidence. So tampering, in effect, what it really results in is a miscarriage of justice. Furthermore, it actually interferes with the prosecution's case. Criminals can also get away on
can I just pause you there? Can I just pause you there? That speaks, and I want us to double click on that because that speaks to the effect of it. But I want to crystallize here, what does it mean for evidence to have been tampered with? Are we talking about the manipulation of, if let's say a voice recording, if you manipulated and edited and removed certain stuff from it, however you may do that, is that a form of tampering?
Yes, it is. When it comes to evidence, the first thing you need to understand is that there must be a chain of custody, how evidence is in effect handled. So when you look at tampering, for instance, evidence is supposed to be tagged and bagged. For instance, a weapon. In other instances, it has to be identified and sealed, like blood or fingerprints, and then it also has to be properly secured. So when you look at tampering in terms of evidence, if it's not bagged and tagged correctly, it can be swapped. Think of changing a similar gun, for instance, or if it's not sealed or kept in the right temperature, the quality of that evidence can be compromised, affecting the results of it. Furthermore, it can also be diluted, for instance, with another substance, affecting the originality of that evidence. Or it can be swapped. Now, if in a blood bank, you've got blood veils. So that swapping of the blood veils takes person's A's blood and mixes it, or at least swaps it with person B, resulting in effect in wrongful conviction.
Does the tampering of evidence automatically render it inadmissible?
More often than not, it will, because ultimately what has happened is that there's been a defeat of the administration of justice. All right. And remember earlier on, I spoke about the ability to challenge evidence. Once it's been tampered with, then the accused person can't challenge that evidence because the originality, the quality thereof has been materially affected. And therefore, there is no case for them to answer. This is why some criminals are able to walk away or beat the rap, as it were, on a technical point, which results from the tampering of evidence.
Yeah, we heard today before the Matlanga Commission as a point of reference around cases where the prosecutions either were stalled or thrown out altogether because of the tampering of evidence, and just the overall forensics capabilities in the South African police service, and its ability to secure credible, useful and impactful evidence that can be presented in a court of law. How rife in South Africa is evidence tampering? And more often than not, who stands accused of that?
Very good question. It's much suspected, but the stats are difficult to come by. And I think to answer the question that you've asked in terms of who stands accused, is that SAPS is the investigative body that is given the powers by the Constitution. So once evidence becomes available, let's say from a crime scene, that evidence becomes the property of the South African police services. And if you think about it, the police then are supposed to ensure that the evidence is safely secured or that the evidence does not disappear. And as you would have heard from the Matlanga Commission, theft of drugs from labs and secured areas, for instance, is where, in effect, SAPS has lost control of that evidence. Therefore, it's generally, well, it is actually SARS that is in charge of securing that evidence, and that is where you would point the finger at.
Do we have a forensic capability and capacity problem in South Africa by and large?
That is definitely an ongoing issue. Number one, we know that we are understaffed in respect of police. When it comes then to evidence, it requires specialized skills. For instance, the understanding of DNA, the understanding of bloods, the understanding of crime scenes. So, in fact, we do have a shortage of well-equipped, well-experienced investigators, scientists who are able to ensure that this evidence is secured properly and ensure that the proper results come from the evidence once it is analyzed, but also, most importantly, to ensure that in a court of law, that evidence and the results received from it are able to be articulated by a qualified person. So yes, I would agree that there is a lack from a South African police services personnel.
Yeah, we're going to have to be there. Advocate Jazz Vilakazi, thank you so much for your time. Really do appreciate it.